Good evening. This is John Milburn for Laws 12066 Land Law. We're into week 4. This week we're dealing with the issue of unregistered interests in Torrens land and priorities. Does that sound interesting? Well, it is. It's possibly less relevant now with today's technology than it was 10, 20, 50 years ago. But still the principles are important, and we're going to run through some of the important legislation, some of the case law, and we'll round it off with a case. So I'd like you to listen very carefully, because when we deal with the case, there'll be aspects of the material that we consider tonight that I expect you'll be able to introduce as authority for a proposition relevant to the case. So thinking caps on, and please take some notes and think about how you can apply the material in a practical sense. That's what we'll do at the end. When we're talking about unregistered interests in Torrens land, we are talking about an example of, if you like, an equitable interest. A legal interest is that which complies with the law. The law requires the holder of an interest in land to register. So therefore, a legal interest is something that is reflected by registration. If it's something which is which creates an equitable right, then it's an equitable interest. So it's not registered, it's off register, but it still has some value. Now the question is then, it's all very well, but how do we deal with competing interests? Registered versus registered, registered versus unregistered, unregistered versus unregistered. In other words, how do we deal with legal and equitable interests where there is a dispute? Which leads us to the topic for this evening, which is priorities. How do we determine the priority when we compare competing interests in relation to legal, equitable interests? So your reading this week relates to various chapters of Sackville and Neave and LexisNexis questions and answers. And I do hope that you're keeping up with your reading, and I'll go a little further and ask you to please read in advance. I know that's hard. You'll be saying, look, it's week 4, I'm already behind, I've got all these assessments that are looming now, so it's a tough time, but you do have a week's break soon. So after next week, you've got one week and catch up and get ahead. Let's firstly deal with some key terms. This is in your study guide. As mentioned, a legal interest, generally in the context of land, means something that is created as a result of the registration process. Equitable interest is something where there is a declaration or some entitlement to pursue an equitable right or claim, as opposed to a mere equity, which is something less than an equitable interest, which provides for personal rights or possibly property rights. So as part of this evening's discussion, we'll be talking about rights in rem, in personam, and you would have dealt with that in previous units. And indeed, I think in this unit as well. And a priority dispute, as we mentioned, is where there are conflicting interests and people claiming to have different interests in relation to property. So what is the basis upon which our Torrens system operates? Well, we know the act that we need to consider in that context. What's the first? I mean, there's 2 main ones, but what's the one that comes to mind in terms of the process of registration of instruments? We all know this, don't we? I'm giving you an easy one so you can unmute or answer through the chat facility. And it is the Land Titles Act. Okay, thank you very much. So, what section of the Act deals with the issue of the order of registration of instruments? Assuming that we have more than one instrument that is to be lodged or affect a title, and what order do they take priority in terms of registered interests? Oh, we're getting lots of votes. 177, spot on. So that deals with the order of registration of instruments. So if you haven't worked it out already, what you should be doing tonight is ensure that you have your Land Title Act handy, because we'll need to refer to some of these sections. So 177 says that Instruments affecting a lot, including instruments affecting or creating an interest in the lot, must be registered in the order in which they are lodged. Do you think that reflects the common law? Yes or no? Trick question, because at common law we didn't have the sort of registered interest. The answer is no. Generally speaking, at common law, the order is based on when the document was created. So here we're not talking about the date of creation. In 177, all that we're talking about is the date, the order in which they are lodged. There's nothing in there that says the date of creation. So keep that in mind. You'll need to remember that at the end of tonight's session. Section 181 talks about an interest in a lot not transferred or created until registration. In other words, at law, until it is registered, it is not an instrument pursuant to the Act. That's the at law component. So Section 181 provides that it is only upon registration that a registered proprietor obtains an interest at law, that is what we call a legal interest. What's a case for the proposition that an unregistered, or if you like, equitable interest can also exist over Torrens title land? It's not in the Act, so we're going to have to rely on case law for this one. What's a case for authority for the proposition that an unregistered or equitable interest can coexist with a legal interest in a Torrens title jurisdiction? Barry and Hyder, very good. Excellent, thank you, Monique. So keep that case in mind as well. So Barry and Hyder considered the issue of equitable interests and whether the lack of registration of the transfer prevented the creation of an equitable mortgage over property. And that means that we now have the potential, don't we, for competing interests. Legal versus equitable, legal versus legal, equitable versus equitable. Priorities. So who's going to win in these disputes if we go to court, each claiming the best interest, the interest that should be upheld as superior to the others? No answers yet? We'll have to wait till the end of the session. Another thing you need to consider, and there's so many things to consider, one is part performance. Now, an interest in land must be evidenced in writing to be enforceable. Does anyone know what section of any Act might be authority for that proposition? What Act do you think it might be? Interest in land, evidenced in writing to be enforceable? It's a trick question. It's not the Land Title Act. Property Law Act, yes. So have a look at the Property Law Act in that regard. So, but it may be that an equitable entitlement exists as a result of what we call part performance by the parties which evidence an agreement. So it may be, if you like, an interest which is created as a result of an imperfection, but there is some performance which creates the equitable interest. For example, whilst many titles these days are paperless, therefore there is no duplicate original, and I think we talked about that last week, it is possible that the owner of a property has a duplicate original title deed and deposits that with a financier in exchange for money. Let's take that scenario. Do you think that there's some act of part performance? And if there is, what would that act of part performance be sufficient to constitute in terms of an equitable interest? And to whom? All right. Any responses? Any thoughts? Are we talking about a potential equitable interest in favour of the owner? If not, the mortgagee. Yes, yes. Justice just got in ahead of Siobhan. But I have to give that one to Justice because Siobhan answered with a question mark, which is, but you're right, you're right. So thank you, Siobhan, for that. And what you don't want in court is, the comment from the judge, are you asking me or telling me? Anyway, so I digress. So we have an equitable interest potentially in favour of the mortgagee. Why is it an equitable interest, if at all? Because the mortgage is not registered. Thank you. Okay, so it's kind of simple in process, in theory, isn't it? And I'm really stripping it down to the basics here, but that's kind of the idea. And the equitable mortgage might be created through the deposit of title deeds. So even though I've said that an interest in land must be evidenced in writing to be enforceable, there is still this issue of perhaps an exception to that, sufficient to create an equitable interest, may arise as a result of part performance. But the law says if you're going to rely upon part performance as the basis upon which to claim an equitable interest, the actions must be unequivocally referable to the alleged agreement. In other words, if there's some other explanation for the actions of the parties, this doctrine of part performance will not be sufficient to allow a party claiming an equitable interest to succeed. I hope that makes sense. Right, let's just look at an important case, because this is one that you probably need to cite in any assessment work around this area of practice. The case is Breskvar and Wall, BRESKVAR against Wall, 1971, 126 CLR 376. We've talked about this previously. Breskvar owned property, wanted a loan, executed a transfer of property for security with the second respondent, Petrie. The transfer wasn't properly executed. The name was left blank, and the second respondent filled in the name of his grandson. Remember we talked about this last week? So you had an improperly executed document. That document was used by the first respondent to register himself, and then tried to transfer it to a third party, innocent bona fide purchaser for consideration. So this case, I guess, is seminal for the decision of His Honour Chief Justice Barwick, who said, yes, whilst there's been some fraud, remember that this is a case that relates to the act of registration. And so even if the situation which led to registration was somehow wrong, there was void, it was void, or there was fraud, the registration of title still vests in the registered person. So it's for that basic proposition that, if you like, for want of a better term, registration is king. All right, so have a look at Breskvar and Wall, and for the purposes of any assessment work that you do, be prepared to cite it. Have a quote, probably from Chief Justice Barwick, and for examination purposes, for the end of year examination purposes, make sure that you've got something ready to pop into an exam question in any area of practice around this. Okay, so Breskvar and Wall, keep that in mind. We've talked about some interests in land that are equitable, primarily to do with mortgagees, but there are other equitable interests in land. Apart from a mortgagee that might have an equitable mortgage, there are some others, aren't there? The buyer of land under a contract that is not settled has an equitable interest. Is that right? If you sign a contract and all you've done is sign the contract and pay the deposit, do you think you have an equitable interest in the land? You don't have a transfer. What do you think? What do you think the test is as to whether you have an equitable interest? Not registered, mere equity, maybe. It is potentially. Thank you, Siobhan. Mere equity, yes, that's good, Karen. All right, so there are different views here. I think that it is an equitable interest if you have an entitlement to obtain an order, say, for specific performance. So an equitable interest may arise through the failure of the written documents and consequent rejection of the registration of the title, or it may be as a result of the failure of a seller to complete a contract. Now, the next case that I want to refer to, and these aren't in chronological order, but it's another one that you want to at least have available to provide a reference as a citation. It's Butler against Fairclough. Fairclough is Fairclough, 1917, 23, CLR 78. Now, this case is particularly relevant for what we're discussing this evening because it considered the issue of priorities between unregistered interests and considered whether or not the equitable interest holder who failed to lodge a caveat amounted to postponing conduct in relation to a competition with a later equitable interest. Now, what does that mean? So what we're saying here is this, that where we have two holders of equitable interests and one of them has an opportunity to lodge a caveat, that failure to lodge the caveat, should it count against them in simple terms, to the point where that is deemed to be postponing conduct. All right, so if I could explain this by illustration, if someone fraudulently decided to sell the same property to two people, signed transfers in favour of the buyers, and the first buyer took the transfer and then sat on it for 2 weeks and did nothing, and the second buyer, 2 weeks later, handed the money over and registered promptly because they insisted on settling at the titles office, handed the money and immediately lodged for registration. Or perhaps, sorry, so that it's equitable versus equitable, it wasn't able to lodge it straight away. But if there was a dispute between those two equitable interests, for some reason nobody could register, who do you think would win out of those two? The one that's first in time or the one that was second in time? Second, first, second, second, first, second. This is good. We're getting almost an even vote. You see, in terms of equitable law, general law, common law, the first in time prevails. So that's an equitable doctrine. But it's subject to this little kicker, and that is that if you hold the first equity, the law would expect you to do something about it. And if you choose not to do so, that might be deemed postponing conduct. And if you're, if you like, for want of a bit of a term, guilty of postponing conduct, then when it comes to a competition between you and the holder of a later equitable interest, you may find that you lose and your priority interest is postponed behind the holder of the interest second in time. That's a lot of words. Did you follow what I was getting at? So the general rule can sometimes be flipped if the law says you should have done something about it, particularly if the person who was coming in second did something to check for it, did a title search, it was all clear. So then you've got this issue of postponing conduct. Now in Butler and Fairclough, it was a little more specific than that because the court said something to the effect, well, you held this equitable interest, you could have at least lodged a caveat, couldn't you? And the question was that postponing conduct in relation to a competition? Okay. I won't give you the answer, but just think about that and have a look at Butler and Fairclough and have something up your sleeve ready for it. The next case that I want you to be aware of and have something ready to go for assessment purposes is J and H Just, that's JUST, in brackets holdings, close brackets PTO Ltd, against the Bank of New South Wales, which was what Westpac was before it became Westpac. 1972 125 CLR at 546. And a good question, who decides that? The court. The court will decide in terms of a competing interest. So in J and H Just holdings, the court had to consider competing interests, equitable interests. It was a question of priorities. Again, there was an issue relating to the effect of a failure to caveat. And the question is, how do we deal with these competing interests, equitable interests, under the Torrance system? So that's another case that you need to consider. And another one that goes with it is Abigail and Lappin. If you have those cases and have a little blurb, you're probably going to do fine in terms of the case law relevant to this area of practice. They're the main ones. If you have a few others, fine. Okay. Now, there is, if you like, this is all within the context of indefeasibility. Indefeasibility by reference to the registration process. We know that. And we know that indefeasibility is incorporated into the Land Titles Act. And it's relevant to the particulars in the Freehold Land Register about the lot. And we know Part 9 of the Land Title Act deals with the issue of registration of instruments and its effect. So when I'm talking about the case law, please remember that that case law remains subservient to the legislation. So you must always consider the legislation in priority, but be ready to argue and refer to cases when they apply. Now, there is a thing called the personal equity exception, and that works in with this concept of indefeasibility. And there's also the issue of unconscionable behaviour, and there are some policy considerations at stake. And when we're dealing with this, if you like, tension between the objectives of the Land Title Act, we must also consider through Equitable, the Equitable doctrine relating to in personam matters. So a starting point, so I'm just sort of tossing in these ideas, asking if you could then start to work on creating a map for yourself, for your assessment purposes, that ties it in a logical way for you. So these are the key elements, and you need to put them in some sort of order. The exercise we do at the end will hopefully help you in that regard a little bit. So we know that the concept of indefeasibility is the essence of the Torrance system. When we're talking about indefeasibility, probably refer to Bresk-Farren and Wall. And that quote that this is a system of registration not a system of registration of title, but a system of title by registration, which is Chief Justice Barwick. So you probably want to put that in for examination purposes. Now, the theory of immediate indefeasibility is the prevailing view of the effective Torrance system, and the case for that would be, again, Bresk-Farren and Wall, maybe Fraser and Walker, which is referred to extensively in your notes. That's probably the other case that you might want to keep in mind. So in terms of now the Land Titles Act, and we're dealing with the priority issue, we have talked about section 177. You need to talk about 178, almost certainly on any question that relates to the issue of priority of registered interests. You need to consider the quality of the registered interests. Have a look at section 184, and that deals with the issue of a registered proprietor holding the interest subject to registered interests but free from all other interests. So look at that. We dealt with that last week, and also look at the exceptions, which are in section 185. Okay, so hopefully you've now starting to map out some sort of idea of the important pieces of legislation, the important cases, and it's up to you now to put it in an order that you're comfortable with. There is the issue of personal equity on indefeasibility. This is where it gets a bit tricky. I'll give you a quote from a case called Mercantile Credits against Shell. And this is 1976 136 CLR 326. You'll find this in Australian property law at 5.125. Personal covenants which do not affect the estate or interest in the land are not indefeasible simply because they're contained within a registered document. I was going to go into a couple of other quotes, but I'll move on from that so that we're not getting too much bogged down in some of the difficulty. Bear in mind, as I mentioned briefly earlier, there may be some issues to do with unconscionability, and this is where there's not a great deal of uniformity in terms of the way in which the law operates, but the unconscionability issues can have an effect on the in personam exception. Have a look at White and Thomas Hall, which is 2004 QSA 89, where the Court of Appeal made it clear that unconscionable behaviour need not be present in every in personam exception claim. Again, a little technical. I'm just going to ask you to note that, do some reading on it so that you've got some ability to structure an answer. Let's now see if we can put this together a little bit. I know that it might seem overwhelming, but I think you've now got some basic tools that you can use in answering a question. Now, the question I've got for you, this case is really simple. Facts are really dead simple. Here's what we've got in mind. So just please make a note of this so we're ready to answer some questions. Bill is the registered proprietor of a lot. Bill owns a house without a mortgage, that is the lot. To start a business, Bill borrows money from Mary on the 1st of January this year, 2018. Bill signs a mortgage and gives it to Mary. You see, Mary's his sister. She doesn't register it. Got the picture so far? Business isn't good. Bill needs more money. He's embarrassed to go back to his sister. He approaches ABC Finance Company. The finance company does a title search. There's no registered dealings. There's no interest affecting the land. And on the 1st of July 2018, Bill signs a mortgage in favour of ABC. Let's just stop there. And without anything more, your task is to advise ABC. So let's think about some of the way in which we'd structure this. I know there's a lot of questions, and you'd be saying, well, yes, did anyone register? Are there caveats? Were people put on notice as to the prior equitable dealings? All of those sorts of things. But how would you structure a question? What's the sort of logical approach that you might adopt in trying to answer a question about priorities in relation to equitable interests? I think the first thing you'd want to do is identify that there are equitable interests. So who has an equitable interest here in this case? Potentially. Mary and ABC. Monique says, identify the timeline. That's always good. Then the quality of the interest. Mary, Okay, so there's a lot of votes for Mary having an equitable interest. If I suggested to you that on what I said, and Justice says both, if I said to you, I think ABC has an equitable interest, would you agree or disagree with that proposition? Agree, agree, okay. Yes, if not registered. Thanks, Emma. I like that qualification. I mean, once it's registered, then it's a legal interest, isn't it? But at the moment that the bank provides the money and receives the mortgage, it's not registered, so therefore it's an equitable interest. So I think we need to, in answering a question about priorities, identify a timeline, as Monique says. I think that's good. Identify who has an equitable interest, and from that we can then determine the quality of the interests, and that will help us to determine who would win in a priority dispute. And clearly, Bill has created inconsistent, unregistered interests in this lot. Now, we've got this priority dispute between Mary's earlier unregistered mortgage and ABC's subsequent unregistered mortgage. Assuming that no one has registered, the legal issue is then to determine which of these unregistered interests prevail. Who do you think prevails in these circumstances? We've got first in time, second in time, Butler and Fairclough, the authority, first in time. So we're getting a difference of opinion. Any more votes coming through? Second, first. All right, depends. Okay, so we're getting different votes and depends, and I think that's probably right. So when you're answering a legal question, you can always make a statement as to who you believe has the superior interest, but there is nothing wrong with, and in fact I encourage you to do this, make a note as to any qualifications or assumptions that you make. There's nothing wrong with saying the question is deficient in that some material facts are not included. Therefore, my answer that the first or the second, as the case may be, has a greater equitable interest is assuming these things, A, B, C. If those assumptions are incorrect, then my advice is that the other one wins. Do you see how you structure that? So just make sure that instead of you giving a definitive answer, you give a positive answer, but don't be afraid to qualify it and provide a statement of your assumptions. So at this stage, we probably don't have enough information to know for sure who would win between Mary and ABC. But remember, of course, that I said in structuring an answer about priorities, it's very important that you deal with the legislation. So I think you would provide some sort of introduction that talks about equitable interests, perhaps puts in a little bit of case law explaining this, identifying who's got an equitable interest in the scenario, and identifying that there is a priority issue here. That's kind of the introduction. Now we need to talk about the legislation, don't we? So if I'm correct in saying that, what is the legislation that we need to talk about in the context of this priority dispute? Land Titles Act 177, says Amanda. Any other votes? 183 LTA, says Karen. Any other votes? Just 2 votes at this stage. You've all got your land. Sarah says 177 and 178. Any other votes? 199 PLA, says Greg. Nadine says 184. Okay, so we're getting some votes there. I think that there are 3 sections of the Land Titles Act that would be the most relevant in these circumstances. So I think you'd have to talk about 177. I think you'd have to talk about 181. and actually probably 183 as well, probably 178 also. So I'll go with 4, looking at those answers. But around that area, I think the PLA 199 would only apply in like a perpetuities type situation. So in terms of the Land Titles Act, you would make a statement, and this is a little bit of IRAC about this, isn't there? Remember the issues, rules, application, conclusion. So in terms of your answer for the priorities question, refer to the Land Titles Act, make the positive statement. Instruments must be registered in the order in which they're lodged. The order in which they're lodged provides the priority. So that's 177 and then 178. I think I may have forgotten to mention 178. And it's not in accordance with the date that they're executed. So you'd probably talk about 181 there. And if you're talking about equitable interest generally, you probably mentioned already Barry and Hyder. Now, if an instrument, see, here's where we need to start talking about assumptions, further information. If an instrument has been executed and lodged for registration and all the requirements have been fulfilled, then that person has a statutory right to registration. And the instrument does not create an interest at law until it's registered, which is 183, which is what Karen said. So I think you need to make those points. And that identifies, for the purpose of the examiner, that you understand the basic procedure. All right, so assuming that we've identified something to do with the Land Titles Act, we now want to talk about the interests of the parties. We want to apply it, don't we? So let's talk about Mary. Her mortgage, executed on the 1st of January, was not registered on the system. So what's the effect of that? If someone chooses not to register their mortgage, even though it's in registrable form, do they have anything? Do they have any rights at all? Equitable, yes. Yes. Risky, yes. But equitable, equitable. Okay. And what's your authority? What's your case for that proposition? Barry and Hyder? Any other votes? Butler and Fairclough? Okay. And you can quote one or two. There's not necessarily going to be a right answer. To be honest, the one that first came to my mind was Barry and Hyder, but Butler and Fairclough is good too. So when you make a statement or proposition in a legal answer, be prepared to cite legislation. If you can't cite legislation, then cite a case, or sometimes you can cite both. So anyway, so she has got this equitable interest. She hasn't registered, but it's capable of registration. Now, apart from registering, is there anything else that she could do? Section 183 is the yes. All right, we're getting some votes. Monique says caveat. Emma, caveat. Sarah, caveat. Amanda, caveat. Okay. So does someone want to tell me what it, Savon, caveat. What is a caveat? I mean, what is it? What does that mean? Any thoughts? It's protection. Buyer beware, puts the others on notice. Are there any conveyances out there? I know there is. I'm looking at Sarah for this. What is a caveat, Sarah? Like, what is it? Is it a court order? Is it? I'm putting you on the spot.
Yeah, you are a bit.
Sorry.
You're right. A caveat is a document that somebody can lodge. They can lodge it at any time. It can lapse, as we've discussed before. It could also be non-lapsing. It's basically just registering your interest. If you're owed money or something along the lines of that, you can lodge it to basically protect that you get paid when the property is sold or transferred.
Yeah. I'm just a little bit dodgy in the last bit, whether someone who's owed money has a caveatable interest. But yeah, but you're right, absolutely right, Sarah. So a caveat is simply a document. It's a document that someone can complete and lodge. Now, I won't pick on Sarah again, but thank you, Sarah. That was very helpful. Can anyone tell me if you need a court order in order to have the right to complete this document? No, no, not at the start. No, but it will lapse. Okay. So if I decide to lodge a caveat over some property that, I don't know, I just like the look of it, I'll just lodge a caveat over that one. I'll just lodge caveats over all these properties. I'll just lodge them over everything just for fun. Can I do that? I don't need a court order. The other side can get a court order to make you prove your interest. Yes. So no, you can't lodge it over everything. So if I did randomly just decide for the fun of it to lodge a caveat over somebody's property, they could make an application to the Supreme Court for an order to remove that caveat and claim the costs against me and claim any damages that they may have suffered as a result of my reckless, foolhardy behaviour. But if I have an equitable interest in property, then I have a caveatable interest in order to lodge that caveat. So Sarah says to lodge a caveat, you complete a document, you go down to the titles office and you say here. So a caveat is like a personal injunction, isn't it? So what's the effect of a caveat? What does it actually do? We know it's a document, someone fills it in, someone signs it, someone takes it to the titles office, registers it. Agree with all that, Sarah? Okay. So what does it actually do? It's a notice to others. It prevents registration of competing interests. I agree with that, both. It stops someone from selling. Yep. So it has all these effects. Technically, it is a notice to others. It is a document that prevents registration of competing interests. And usually it's most often used to stop someone from selling, but it need not be for that purpose. But it does prevent the registration of something that would compete with that interest. Okay. So from a practical perspective, why wouldn't, if you were going to go to the trouble of preparing a document, signing it, and taking it down to the registry, and it was a caveat, why not just take your mortgage? Any thoughts? I mean, Mary's got a mortgage, hasn't she? Why would you advise Mary to go and lodge a caveat? Or would you say, Mary, just go and lodge the mortgage? Wouldn't that be more sensible? So, caveats have their purpose, but if you have your registrable document and you are ready to enforce your rights and have a legal interest, why not just register the mortgage? But there might be some other reason. Maybe Mary locked it in a safe and she lost the key, and she couldn't find the key and she couldn't dig out the document and she was stressed. Then she might lodge a caveat because she heard that Bill was threatening to go and see a financier or something. So what authority do you have to lodge a caveat? Is there an act or a case? And if there is an act, what? So Kerribee Park and Daly, I'm not familiar with that case, but that sounds good. I mean, is there a case or is there a statute? If a court says, what right have you got to lodge a caveat, where would you look? It was the first place to say, well, there's a part in the Land Title Act, yes. 122 says Karen, yes. We're in the right territory now. So an unregistered equitable interest is an interest that is capable of being protected by a caveat. Have a look at the Land Title Act, look at sections 121 to 131, and any person claiming an interest in land may lodge a caveat to prohibit dealings in the land that would affect their interest, which is section 124. The caveat is recorded by the registrar. Where does the registrar have its powers conferred upon it? And Leonie's cheating. She's got 2 people thinking for her, not just one. She couldn't hear that. So the registrar, section 29, has power to lodge the document. So here, Mary hasn't complied with the caveatable provisions to protect her interests. She hasn't lodged her mortgage, so she still has an interest, but the question might be, what advice would you give to Mary at this stage, apart from the obvious of lodging your document? If it came to a dispute of equitable interests, is there something that would worry you?
Excuse me, John. Can I just ask a quick question? You mentioned before, you said, why wouldn't you just lodge a mortgage? You know, why would you lodge a caveat? Is there any sort of criticism in case law about mortgagees, you know, choosing one over the other and then, you know, perhaps being penalised in some way for that?
Yes, absolutely. And we talked about it before in the context of postponing conduct, didn't we?
Yep. So if they lodged a caveat but didn't lodge the mortgage, is what I'm getting at. You know, usual practice would be to lodge the mortgage, but is the form an issue?
So if you lodge the caveat and you didn't lodge the mortgage, then you run the risk that the caveat would lapse.
Okay,
and
great.
After that, the other side can jump in. So thank you, Monique. No, appreciate that. And remember, of course, that and what I'm really getting at now is the issue of postponing conduct. Greg says the purpose of a caveat to allow time for the parties to apply to enforce or determine an interest in a lot or some other interest under the Land Act. However, caveat does not provide all the benefits, and the Torrens System Land Title Act should not be seen as a viable alternative to registering. Yep, oh, and that's from the Land Title Practice Manual. Yep, so that's very much along the lines of what we've been discussing. So it's a poor substitute, really, for actually lodging. But if you choose to do neither, or you do the caveat but let it lapse, then of course you've got issues to do with whether you have engaged in postponing conduct, which means that the general law about first in time prevails may not prevail in these circumstances. So the general law priority rules will generally apply. So you've got to think about the general rules at common law. That means knowing something about this principle. If all other things are equal, the first in time prevails. There's a really old case that supports that authority. Does anyone know it? You know, we've talked about this equitable principle, first in time prevails, but Rice and Rice, very good, Monique. Excellent. So that's a handy little case to keep up your sleeve. That was from 1853. You don't need to read it, but just know about it and be prepared to refer to it in that context. Okay, and a subsequent equitable interest cannot prevail over an earlier interest if the holder of the later interest had notice of the earlier interest. So, you know, we were talking about assumptions in this case. What if ABC had, you know, what if Bill had said, look, I've got to be honest with you, I'm applying for money, but I did borrow money off my sister. I gave her a mortgage, but she didn't bother to register it. If you're advising ABC, are you allowed to say to your client, well, don't worry about it. Look, first in time prevails. You're going to win anyway. Can Mary attack that situation down the track? Well, possibly. So even though I'm saying there is this issue of indefeasibility and first in time prevails in terms of registration, the holder of the equitable interest may be entitled to seek redress if it can be established by that person that the later equitable interest holder had notice of the earlier interest. So that commentary relates to, if you like, a priority dispute between equitable and equitable. If one of them, the second one registers, even if they've got notice, they're probably going to win. So I just wanted to make that clarification. I hope that makes sense. All right, so what we've discussed in this little case, very simple little case, is that in structuring an answer about priorities, you need to consider the general principles, identify the different interests, talk about the statutory provisions, talk about some of the options that are available to the parties, registration, caveat, do nothing, give notice, things of that nature. Then talk about whether there has been some disentitling conduct, fraud, unconscionability, postponing conduct, and then be prepared to provide an opinion, but all the time identifying any assumptions that you might make or statements about clarification of the facts. I hope that provides some structure to help you in answering these questions. Tonight, you need to make a note of going through the legislation, going through the case law, and matching it in a way that makes sense to you. Ready for an exam question. All good? Okay. Thank you very much. Are there any questions before we sign off?
John, I've got a question. Sorry.
Yes, Leonie?
Are you going to be putting this up tonight, or is this going up tomorrow?
Tonight. Is that okay?
That's perfect. Thank you.
All right. Good. Okay. All good. We'll see you next week. All the best. Bye then.